Oh, but wait, there's more. Because not only do you not own the recording, you don't own anything in or on the recording, which would include your vocal performance, which is embodied within the recording. So when 50 Cent accuses Rick Ross of using an unauthorized sample, even if Rick Ross didn't get permission to use the sample, only the owner of the sample recording has what we call standing or the right to sue. And that would be Shady Aftermath Records. That's right, the label owns not only the recording, but everything embodied in the recording, which includes 50's vocal performance.
There's someone you should know.
Hey everybody, welcome to the BOMB Podcast. BOMB stands for Business of Music Bootcamp, which means that this is the place where we will drill down on the business and legal aspects of the music industry. Everything from copyrights and contracts to policies and practices. Whatever it takes to educate and empower you with the knowledge you need to make informed decisions about how to protect yourself and your music is what you'll find on the BOMB. I'm your host, Professor Butler, and as a retired entertainment attorney, former record label executive, music law professor, and college administrator, I have counseled thousands of artists and musicians on the intricacies of the music business. Now it's your turn.
The information in this podcast is not intended, nor should it be construed as legal advice. If you have questions of a legal nature, we strongly recommend that you contact an attorney in your local jurisdiction who specializes in music and/or entertainment law. For guidance, check out our website at professorbutler.com and sign up to receive a free resource on how to find the right lawyer for you. And now, your host of the BOMB Podcast, Professor Butler.
Hey everybody, welcome to the BOMB Podcast, episode number 9. I'm your host, Professor Butler, and in this week's episode, we will discuss the right of publicity, as well as the name and likeness provision that exists in almost every recording contract. Each of these issues are at the center of the lawsuit that 50 Cent filed against Rick Ross a few years ago, and that very same lawsuit actually came to an end just last week. If you follow the rap world, you already know that there has been bad blood between these two rappers for more than a decade. And although I don't plan to go into all of the salacious, maybe a few, but not all of the salacious reality show type details of their dispute, I do plan on giving a little background for those of you who may not be familiar with how and why their beef came about. Now, you know me, I have to define every little thing. So for those of you who may not be familiar with the term, a beef is more than just a simple disagreement. According to the Urban Dictionary, in the world of rap music, when someone has a beef with another rapper, it means that they're either picking a fight with them due to a grudge, or they just don't like the person that they have the dispute with due to differences in opinions, differences in maybe their lifestyle, culture, or anything else they just don't agree on. The beef is generally expressed lyrically when you insult or call out someone in your rap song, although beefs have increasingly been expressed through the media, social media in particular, and, as we will see in this case, through the courts. So, where did it all begin? Well, this particular beef began in 2008. 50 Cent, whose given name is Curtis Jackson, was being interviewed. And during that interview, he actually complimented Rick Ross, legally known as William Roberts, on the success of Ross's #1 album. In that same interview, however, 50 also warns Ross not to stand too close to Fat Joe, another rapper who was feuding with 50 and his rap group G-Unit at the time. So basically, although he was complimenting Rick Ross, he was also saying, but watch out and don't get too close to Fat Joe because we don't like Fat Joe. We have a problem with Fat Joe. And basically, he was suggesting that any friend of an enemy is an enemy of his. So the friend of my enemy is my enemy. All right. So the beef continues. Because later that year, during the 2008 BET Awards, Rick Ross saw 50 Cent at the award show, but didn't like the way 50 looked at him. 50 would later claim that he didn't even remember Rick Ross even being at the award show, which is somewhat of a slight in itself, right? And if you're curious, where is she getting this information? I found a history of the beef from 2008 to 2018 on a website called the DJ Booth. I even posted a link to that article in the notes if you're really, really curious about every single step in their process. The beef continued through each of the rappers' videos, lyrics, and interviews, but it got really, really personal in 2009 when 50 posted a 13-minute sex tape that appeared online featuring a wig-wearing 50 Cent as the narrator, who not only taunted rap rival Rick Ross, who wasn't even in the video, but made explicit remarks about the woman who was in the video, who just happened to have a daughter with Rick Ross. In other words, right, in street terminology, 50 posted a video of Rick Ross's ex-girlfriend / baby mama having sex with another man, and according to the blogs, even superimposed his face onto the face of the woman's then boyfriend. Now that's bad. Unfortunately for 50, the woman sued him for posting the video online without her permission, which led to a jury ordering the rapper actor to pay $7 million in damages, $5 million in regular damages, $2 million in punitive damages, which are meant to punish the offender. 50 later filed bankruptcy to avoid payment of damages. All right, so that's enough gossip. Let's fast forward to December of 2015. Rick Ross does a remix of 50's 2003 hit In the Club, which is from 50's chart-topping album Get Rich or Die Trying. So Ross samples In the Club using parts of 50's voice, right, to include in his Renzel Remixes mixtape. And throughout the mixtape, he continuously shouts the name of his soon-to-be-released 8th studio album, Black Market. 50 hears the mixtape, hears the remix, and immediately files a $2 million lawsuit against Ross, accusing him of illegally sampling the song and the unauthorized use of 50 Cent's name, identity, and trademark. Now, remember from a previous episode, trademark identifies goods and services in the marketplace and distinguishes them from other goods and services. So in this case, the mark would be consisting of 50's name, which Ross also included in and on the mixtape. Unfortunately for 50, again, 3 years later, in 2018, a federal judge in Connecticut ruled that rapper 50 Cent's $2 million lawsuit against Miami rapper Rick Ross lacked merit because 50 does not own the copyright or the master recording of In the Club. The master is owned by 50's then label, Shady Aftermath Records. Okay, now let's stop here for a moment because I want to explain a little bit about what's going on. When 50 Cent signed a record deal with Shady Aftermath Records, just like when you sign a record deal with a major label or maybe even a major independent, he signed what is known as a work made for hire agreement. I decided that next week, I'm going to do an entire episode on work made for hire because it can be really complicated. But for now, what you need to know is that generally, in the world of copyright, whatever you create, you own it, right? However, when a work is considered a work made for hire, whatever you create, you don't own. It is actually owned by whomever ordered or commissioned you to create it. Record contracts, for the most part, are all work made for hire agreements because the record company is hiring, ordering, and commissioning you to create a work, in this case, a sound recording or an album. Now, it's true that some works, like movies and videos, also known as motion picture and audiovisual works, are automatically considered works made for hire, but most works are not. which means in order for what you create to qualify as a work made for hire, you have to sign an agreement that says that the work you're creating is a work made for hire and acknowledge that you realize that it's a work made for hire and that you will not own the rights to that work. Whenever you sign a record contract, you're signing a work made for hire, which means you will not own your work. You will not own the master recording. Oh, but wait, there's more. Because not only do you not own the recording, you don't own anything on or in the recording, which would include your vocal performance, which is embodied within the recording. So when 50 Cent accuses Rick Ross of using an unauthorized sample, even if Rick Ross didn't have permission to use the sample, only the owner of the sample recording has what we call standing or the right to sue. And that would be Shady Aftermath Records. The label owns not only the recording, but everything embodied in the recording, which includes 50's vocal performance. So, with all that said, because 50 does not own the master, he cannot sue on the master, and his case was thrown out of court. However, he refused to give up, and a year later in 2019, he filed yet another lawsuit, an extension of the original, but this time claiming that Ross's use of his voice on the mixtape was used without his permission, therefore using his name and brand for advertising purposes without his consent. And according to 50's lawyers, 50, aka Mr. Jackson, quote, does not challenge the unauthorized use of his voice in a purely entertainment work. He challenges the unauthorized use of his voice as part of commercial speech or an advertisement for a collateral product, also known as Black Market, which is Rick Ross's album, for which he has no connection to whatsoever. Now, remember when I said that Rick Ross shouted the words Black Market throughout the song? What 50's lawyers were saying that they were likening the song to an advertisement of Rick Ross's then upcoming album. This is where we get into the right of publicity. The right of publicity prevents the unauthorized commercial use of an individual's name, likeness, or other recognizable aspects of one's persona, including their voice. And by the way, you also have a right of publicity that is supposed to prohibit people from using your name, likeness, or other recognizable aspect of your persona for commercial purposes without your permission. So the right of publicity gives an individual the exclusive right to license the use of their identity for commercial promotion. Basically, it gives you the right to make money off your name and likeness. And basically, under the right of publicity, no one can use your name or likeness for commercial gain or purposes without your permission. In the United States, the right of publicity is largely protected by state law, either state common law or statute. And only half of the states have distinctively recognized a right of publicity. And out of that half, many of them do not recognize a right of publicity by name, but they do protect your publicity rights as part of your constitutional right of privacy. According to the Restatement Second of Torts, which is a legal treatise or book of arguments, the restatement recognizes 4 types of invasions of privacy. They include intrusion, appropriation of name and likeness, unreasonable publicity, and false light. Now, when I say restatement of torts, a tort is a civil wrong that causes a claimant to suffer loss or harm, resulting in legal liability for the person who committed the tortious act. It can include intentional infliction of emotional distress, that's a tort, negligence, financial losses, injuries, invasion of privacy, and many other things, including the invasion of your right of publicity, which is what we're talking about here. And depending on the state, there are several torts that protect the right of publicity. They include the law of unfair competition, right, which is a deceptive business practice that causes economic harm to other businesses or to consumers. There's actions for misappropriation or for wrongful attempt to pass off the product as endorsed or produced by the individual, and that helps to protect their right of publicity as well. If a person can establish an aspect of his or her identity as a trademark, protection may be provided by federal law. And the Federal Lanham Act can also provide protection where a person's identity is used to falsely advertise a product or designate its origin. So basically, even if there's not a right of publicity law on the books, you can still protect your privacy rights by unfair competition claims, by a misappropriation or passing off claim, by a trademark claim, a false advertising claim. But in this case, 50's claim is for the invasion of the right of publicity, which is most similar to the unauthorized appropriation of one's name or likeness. So let's get back to the court case. The lower court, right, the one that held against 50, said that when 50 recorded in the club, pursuant to an agreement with his then record label Shady Aftermath, that specified that he owned no copyright interest in that song. Okay, we know that, right? He doesn't own any copyright interest in the sound recording because his recording agreement was a work made for hire. Okay, we get that. However, in addition, the court also says that 50 signed away his name and likeness rights in his recording agreement. What? That's right. This is the part I need you to pay attention to because no one ever pays attention to this provision in their contract. In 50's recording agreement with Shady Aftermath, 50 granted to the label the perpetual, which means forever. I'm going to repeat that. The perpetual, I repeated that on purpose, and exclusive rights during the term of the recording agreement and the non-exclusive right thereafter to use 50's name and likeness for the purpose of trade or for advertising purposes in connection with the marking and exploitation of phonograph records and covered videos. And just like almost every record contract there is, it's a work made for hire, right? Almost every record contract contains this same name and likeness provision that I just read. And I'm going to read it one more time just so that you remember. 50 granted to the label the perpetual and exclusive right during the term to use his name and likeness for the purpose of trade or advertising. Does that make sense? So 50 owned his right of publicity, but he transferred or assigned his right to his record label. So basically, not only did he not own the master, he didn't own his publicity rights either. Now, let's look at why this is from the label's perspective. If I'm investing hundreds of thousands, even millions of dollars into your music and into your career, I need to get a return on my investment. And the best way to do that is to own the outcome of my investment, which is the album or the sound recording that you recorded in that studio. Now, of course, that doesn't mean that I should own it for the next 120 years from the date of creation, which is the copyright duration for a work made for hire. But unfortunately, you can't really get a reversion, meaning they can't give you the copyright back on something that you never owned in the first place, because it was a work made for hire. They may, if they choose to, assign copyrights to you after a period of years, but we're going to talk about that much, much more next week. In regards to the name and likeness part, the label needs to be able to advertise and promote and sell the album using your name and your pictures and your bio, and they can't do any of that unless they get your permission to do so. So while they're having you sign away everything else you own, they might as well have you sign over your name and likeness rights as well. And that's exactly what happened to 50 Cent. The lower court ruled in Rick Ross's favor, finding that 50 had signed away his rights to the song, as well as his right of publicity to Shady Aftermath for the term of their recording agreement. he could not pursue a case against Rick Ross for using the song. Now, last week, the U.S. Court of Appeals agreed with the district court, finding that while Ross did not obtain permission from Shady Aftermath to include In the Club in his remix, right? And he did not get their permission to use 50's name as a featured artist on the mixtape. 50, in his recording agreement, had surrendered his rights to the use of his name, performance, and likeness associated with the master recording of In the Club in connection with advertising and the marketing of phono records, and Rick Ross's mixtape is a phono record. Because of that, the court ruled that Jackson's right of publicity, or 50's right of publicity, claim is preempted because he cannot assert a tort action based on the rights that he contractually surrendered, meaning you can't sue somebody for rights that you don't own. In deciding to uphold that lower court decision, the appeals court ruled that Ross was presumably liable for copyright infringement, but not to 50 Cent, to Shady Aftermath. The court also said that 50 may have the right to compel Shady Aftermath to sue Rick Ross for copyright infringement, right? Or to seek damages from Shady Aftermath for its failure to protect his rights to royalties by suing Rick Ross. But he did not have the right to go personally after Rick Ross himself. Only Shady Aftermath can pursue a lawsuit against Rick Ross for copyright infringement, not right of publicity. Ross's attorneys later claimed that Rick Ross's remix of In the Club was never even about 50 Cent, but was simply one of the many remixes on his mixtape album, which also featured songs by Adele, Nas, Snoop Dogg, Kendrick Lamar, and Lil Wayne. And just so you know, artists often perform lyrics in sampling or remix songs of other artists, as it has long been a staple of practice in hip-hop music. Whew. Okay, so what have we learned in this episode? Well, first of all, we learned that beefs are common among rap artists, but this 12-year-old beef and counting between 50 Cent and Rick Ross is definitely one for the history books. We also learned that most recording agreements are work made for hire agreements. As a matter of fact, throughout my career, maybe I saw 2 that were purely assignments, meaning that you will not own your master sound recording, nor will you own the vocal performance embodied within those recordings. We learned that most states have either an express right of publicity law or some other law that protects you from someone using your name and likeness for commercial purposes without your permission. And we learned that most recording agreements contain a name and likeness provision that requires you to assign your right of publicity to your record label for the term of the agreement exclusively and non-exclusively beyond the term of the agreement. Finally, we learned that just because it's your voice, you may not have the right to sue someone for using it if you otherwise assigned your right of publicity rights to someone else. All right. Well, that is it for this episode. It may not be it for the beef, but this is it for this episode. I hope you enjoyed it as much as I did. And don't forget to leave a review or tell a friend about this podcast if you think that they can learn from it or be empowered. I greatly appreciate it. And with that said, I will see you next week. Thanks for joining me on the Bomb Podcast. If you were educated, empowered, or inspired by what you heard, please subscribe today to be the first to receive the latest episode. And don't forget, post a review, tell a friend, follow me on social media, and join my tribe at ProfessorButler.com.